Obviously, the police believe that you killed Kenzie. Did you kill Kenzie?
Orton pleaded guilty in March to stabbing his parents to death, even using an axe to kill his...
Any type of crime involving an innocent child is horrible.
In 2001, Jane Dorotek was sentenced to 25 years to life for the murder of her husband, Bob. Despite her conviction, Jane insisted she was innocent. Years later, new defense attorneys took up her case, questioning the state's evidence and undermining the credibility of what had been used to convict her.
Ms. Dorotek, I know this has been dismissed. The case is dismissed. You are discharged therefrom.
And I hope now we have an opportunity for some healing and reconciliation.
On May 16, 2022, prosecutors dropped all charges against 75-year-old Jane Dorotek, a mother of 3 and a successful healthcare executive. For 22 long years, Jane endured a painful journey, all the while believing in her innocence. The relationship between Jane and her husband, Bob, had been troubled, leading investigators to suspect a motive for his murder. The prosecution painted the crime as a cold, calculated act. They argued that Jane killed Bob in their bedroom and then moved his body to a wooded area where it was later found. After 4 days of deliberation, the jury convicted her of first-degree murder. Despite the conviction, Jane never stopped fighting to clear her name. DNA tests on the rope, Bob's fingernails, and clothing revealed that the DNA did not match Jane's. Her lawyers also cast doubt on the reliability of some forensic evidence, questioning the integrity of the criminalists involved and the lab that processed it. In 2020, Jane's murder conviction was overturned, and she was released from prison. However, prosecutors initially planned to retry her for Bob's death. But on May 16, 2022, they dismissed the case, citing that the remaining evidence was insufficient to prove her guilt beyond a reasonable doubt. Jane expressed her deep gratitude to the Loyola Project for the Innocent for their thorough investigation and for giving her the chance to testify against her conviction.
And she says she's going to Florida to spend some time with her daughter, but Innocent had a lot of strong words for the DA's office as well as for the criminal justice system, as they did tell us through a statement that they could no longer ethically proceed with this case because there isn't enough evidence.
Jordan Brown was just a kid when he was accused of killing his father's pregnant fiancée, Kenzie Hook, in New Beaver, Pennsylvania, back in 2009. Although he was acquitted of homicide charges, he was found guilty of involuntary manslaughter and sentenced to 2 to 5 years in juvenile detention. Jordan's case garnered widespread attention and sparked a heated debate about whether children should be tried as adults. Supporters argued that he was too young to fully understand his actions, while others believed that, given the severity of the crime, he deserved to be held accountable. The tragic events unfolded on February 20, 2009, when Kenzie Hook was found shot to death in her home. Jordan, who was in the house then, quickly became a suspect. He was arrested and charged with first-degree murder. During the trial, his defense team maintained that Jordan was innocent and had been framed. They pointed out that the gun used in the killing belonged to Jordan's father and suggested that someone else might have committed the crime. After 2 days of deliberation, the jury acquitted Jordan of first-degree murder and criminal homicide, but found him guilty of involuntary manslaughter. He was subsequently sentenced to juvenile detention for 2 to 5 years. Jordan was released in 2015 and has since kept a low profile with little known about his life.
Obviously, the police believe that you killed Kenzie. Did you kill Kenzie?
No.
Did you understand what you stood accused of?
No, I didn't understand. I was crying in the picture. I was crying that whole night. I didn't understand what was happening. I didn't know where I was at, like what was going on or anything. No, I'm not angry. I mean, I think the whole, like what happened and the way it happened is BS.
So what made you need to be there?
He's my son.
What do you want to tell the world about you?
That I'm innocent. That's like the only thing I really want people to know. Everything's gone. And that made me happy, and then the truth finally got out. I want to be successful. I just want to graduate college, you know, get a job in my major.
David Cam, a highly regarded Indiana police officer, was wrongfully accused of murdering his family, largely due to faulty forensic analysis. In September 2000, his wife Kimberly and their children, Bradley and Jill, were tragically found dead in their Georgetown home. The charges against Cam were based on a flawed interpretation of bloodstain patterns on his t-shirt, made by a crime scene photographer who lacked formal training in bloodstain pattern analysis. The key expert witness used to convict Cam was Rodney Angert, who had also played a significant role in wrongfully convicting another innocent person, Julie Ray. This reliance on questionable science led to a grave miscarriage of justice in Cam's case.
Extramarital affairs to allegations of sexually abusing his own daughter. Sex has been at the center of David's
have lingered in the court of public opinion. Tonight, David Cam talks about all of it.
I was just in complete, utter shock and disbelief, properly buried. I'm sitting in a jail cell.
You think about him every day.
Clutter led the post-conviction investigation for the Illinois Innocence Project, which he founded in 2001. During his investigation, he uncovered 2 key witnesses who placed another suspect in Lawrenceville at the time of the murders, which convinced Texas Ranger John Allen to sign an affidavit supporting Julie's petition to overturn her conviction. Nearly 5 years after David Cam was first arrested, forensic experts identified the real killer as Charles Boney, a career criminal who had been released from prison just a few months before the Cam family was murdered. Despite this new evidence, David Cam remains in jail, awaiting a 3rd retrial. The case has been plagued by tunnel vision, as investigators and prosecutors overlooked crucial evidence, such as a sweatshirt found at the crime scene with the word backbone written in black ink on the collar. In February 2005, Charles Boney was identified through CODIS, a criminal offender DNA database. Known as the Shoe Bandit due to his history of stealing women's shoes, Boney had spent nearly a decade in prison for these crimes. Initially, Boney denied any connection to David Cam or that he had given his clothing to the Salvation Army. However, when police discovered his palm print on Kim Cam's Ford Bronco, he changed his story. Boney was then given a choice: testify as a witness for the prosecution to help reconvict Cam or face the death penalty himself. His story, however, failed to explain how Kim Cam's saliva ended up on his sweatshirt or how his handprint was found on the Cam family's Bronco.
In the case, Cam sued 11 people or organizations, seeking a total of $30 million.
For the benefit of our family. So I think it's a misrepresentation to say.
Paul Shane Garrett, wrongfully convicted of a brutal murder in 2003, is now seeking $18 million from the city of Nashville. Garrett had been sentenced for the 2000 killing of Velma Tharp, a crime he did not commit. Following efforts by the Tennessee Innocence Project and a new report from the Davidson County District Attorney's Conviction Review Unit, all charges against Garrett were dismissed, affirming his innocence.
Today, Paul Garrett initially pleaded guilty to the murder of Velma Tharp in 2000.
Then 20 years after a murder he didn't commit, this moment, he says, was priceless.
I didn't get to watch my kids grow up. It wasn't in their life.
To Velma Tharp, and we owe that to Paul Garrett. And I feel privileged to have been a part of writing this very.
It affected my ability to get a job. It affected my ability to trust anyone.
For the murder of a Nashville woman in 2000. But now DNA evidence points to a different man.
Words earlier, no, I did not, when he was asked if he was the man responsible for Velma Tharp back.
Part of righting this very tragic wrong.
I just tell guys or women or guys, don't give up on anything.
Garrett is now suing the city and 5 individual police officers for their roles in the investigation that led to his wrongful imprisonment for over 10 years. The lawsuit alleges that Garrett repeatedly told officers nearly 50 times that he was innocent, yet detectives tried to force a confession from him by lying about DNA and other evidence. Officers Dunaway and Bernard were publicly found to have lied under oath and fabricated proof multiple times, including during the Tharp investigation. Garrett's lawsuit highlights the severe and immeasurable losses he endured, including the loss of 18 years of freedom, missed opportunities to bond with his family, the inability to maintain and pursue a career, and the lasting embarrassment and damage to his reputation caused by his wrongful conviction. Ethan Orton, a teenager from Cedar Rapids, was sentenced to life in prison after admitting to killing his parents in October 2021. In February 2023, Orton pled guilty to 2 counts of first-degree murder for the deaths of Misty Scott Slade and Casey Orton at their home. According to court documents, when police arrived at the scene, they found Orton sitting outside the house, covered in blood.
Orton pleaded guilty in March to stabbing his parents to death, even using an axe to kill his mother.
In prison, except for juvenile defendants. Orton was just 5 months away from being 18 at the time of the
learning experience, but I'm very grateful that this can be fixed even after being up here, knowing that this is something that needed to be addressed, especially something that...
Police reported that Orton confessed to stabbing and killing his parents because he wanted to take control of his life. They also stated that he used an axe to kill his mother after she appeared to survive the initial stabbing. Orton faced 2 counts of first-degree murder. His defense team initially requested a competency evaluation, arguing that Orton was suffering from a mental disorder that prevented him from fully understanding the charges against him. After a medical evaluation deemed him competent to stand trial, Orton's defense submitted a notice of insanity and diminished responsibility to the court in January 2022. This led to a delay in the trial in February 2022. First-degree murder, in this case, carries a mandatory minimum sentence of life in prison, with Orton required to serve at least 50 years before he is eligible for parole.
Trial. That's because Ethan Orton pleaded guilty today to stabbing his parents to death in October of 2020.
Household. Mr. Orton is somebody who's very vulnerable. He is very dismissive, demeaning of him, belittling, harsh.
He didn't have any cognitive deficits, so he was normal.
Barry Walker, a 58-year-old former doctor from Glenwood, pleaded guilty to multiple counts of child exploitation at the Clark County Courthouse. He was sentenced to 21 life sentences, adding to nearly 40 life sentences he is already serving. This plea came just 1 day after Walker received an 18-life sentence from a Pike County judge. In total, across both counties, Walker faced 34 counts of exploitation, 29 counts of computer child exploitation, 28 counts of producing or promoting explicit performances by children, and 29 counts of involving children in explicit conduct. The abuse occurred over 23 years, with incidents reported in Glenwood and Amity. During the court proceedings, it was revealed that Walker often used melatonin to sedate his victims.
Charges date back to allegations from 1997. Various computer crimes related to the offenses.
Any type of crime involving an innocent child is horrible.
And there's 31 individual victims. We filed 34 felony informations in both Pike and Clark County.
It is a difficult case.
And of those 34, 33 involve rape allegations
But the magnitude of what we're investigating and the amount.
Turner requested the maximum sentence for each charge as part of the plea agreement and received it. During the proceedings, Turner read victim impact statements for several victims and became visibly emotional.
We talked to those girls quite a bit, but I think when the court hears firsthand, I do think justice was served today in the courtroom. However, my opinion, there's no amount of time that could be given to Barry Walker.
The scope of these offenses is kind of breathtaking.
Today that Barry Walker did not win. They won this case that will take what he robbed from these little girls.
We got the maximum sentence for each count, for each child, for each victim.
Turner read a statement from one of the victims that said, "God would never appreciate what you did," and described Walker hitting the girl's sister. The statement concluded, "I just want you to know that you deserve what you are going through right now. I hope you rot in hell." Another victim wrote about her ongoing struggle with guilt and her mother's feelings of blame, affirming, "I know that it isn't our fault. What happened is disgusting, and you are disgusting." Walker faced an extensive list of charges: 39 Class of felonies, 76 Class B felonies, 17 Class C felonies, and 11 filings for sentence enhancement for offenses committed in the presence of a child. The sentencing range was 10 to 40 years or life in prison for each Class A felony, 5 to 20 years for each Class B felony, and 3 to 10 years for each Class C felony. A Milwaukee County judge sentenced Darius Robinson to 125 years in prison, with an additional 65 years of extended supervision. This sentence follows his conviction on multiple charges related to the physical exploitation of 3 women in early 2019. Robinson was found guilty in November 2019 after a week-long trial. The criminal complaint details the alleged assaults on the 3 women. One of the victims reported that on April 15th, she met Robinson through a website and agreed to meet him near 53rd and Center.
But I don't think you begin to understand or care about the effect.
And 25 years behind bars. Now, it is a lengthy sentence, but as one a judge.
What matters is how your selfish actions have affected them and their families.
According to the complaint, Robinson lured the woman to a rear alley where he grabbed her by the hair, took her cell phone, and pulled out a handgun. He then forced her to engage in intimate acts. The woman managed to escape and reported the attack, providing a detailed description of Robinson and his clothing. When officers examined the woman's cell phone, they found a VoIP number linked to an email address under Robinson's name. 3 days later, a search warrant was executed at Robinson's home, where officers discovered clothing items matching the victim's description and a .177 caliber BB gun, which closely resembled a real handgun. Bernard Jackson, a 53-year-old man, was sentenced to 18 consecutive life sentences by a Jackson County judge after being found guilty of 7 counts of exploitation related to attacks from 1983 and 1984. Jackson was convicted of breaking into the homes of women living alone in Waldo, where he exploited and robbed them.
In each case, he broke into their homes. In every case, that man either displayed a gun to them, either through a door or a window. In one case, it was never determined how he broke in, or he threatened them with it.
Jackson was convicted of 18 felonies, which included 7 exploitation charges, 7 counts of sodomy, and 4 robbery charges. The sentence he received was the maximum allowed. Jackson's attorney announced plans to file an appeal, and Jackson continued to claim innocence. The conviction was based on a combination of DNA evidence and witness testimony. Jackson had previously served over 30 years in prison for unrelated physical exploitation charges.
I usually just stayed in the house or walked with somebody. I didn't, go out by myself or anything like that.
Makes her stand up and gets behind her, and he's very careful.
18 life sentences without the possibility of parole. That's what a Jackson County judge sentenced Bernard Jackson to today.
He will never victimize another person again because of today.
He lifts her out of the bed.
Very prolific, very good at what he does, which is very bad, and fortunately.
But hoping that you understand the science, what you end up with is an innocent man sitting in front of you. And when those mistakes are amplified, and hoping that you understand the mistakes that were made, scared to death of these accusations.
Jackson also faced another trial for exploitation crimes committed in 2009 and 2010 in Waldo and Brookside. This case revolved around a man named Larry Whaley. On December 2nd, 2016 in Cerro Gordo County, Iowa, Larry discharged a firearm, resulting in the death of 19-year-old Samantha Teeter. The police soon arrested and charged Larry with the crime. The court is tasked with evaluating each situation by considering all pieces of evidence, including testimony.
Investigator McChesney, I've handed you what's been marked as State's Exhibit number 5. Do you recognize this?
Yes, this would be the gun case.
Okay. And if you open it without showing the jury, just look inside first and see if there's anything inside it. Do you see, it's marked as State's Exhibit 4. Do you see that?
Yes, it is.
And can you tell us what a State's Exhibit 4 is at this point?
Okay.
And is there a cable lock that is on the make it safe?
Yes, there is.
And if you would look at the, make sure it's not loaded in any way.
Yeah, it appears to not be loaded.
Is this the State's Exhibit 4, the inside State's Exhibit 5? Is this the .44 revolver we've been talking about?
Yes, it is.
The state would offer in evidence State's Exhibits number 4 and 5.
No objection.
State's Exhibit 4 and State's Exhibit 5 are admitted.
Your Honor, if the state may have permission, I'd like to hand the investigator a pair of gloves just to show the jury the State's Exhibit 4 and then to put it back into State's Exhibit 5.
That's fine.
And Investigator McChesney, when you're doing this, I know you mentioned the gun's not loaded and has a cable lock on, but if you just be careful to how you're pointing, not pointing in anybody's direction.
Yes, I'll do that.
Thank you. If you would remove State's Exhibit 4 and just so you can show the jury what it looked like. Thank you.
You may.
You showed us there was 3 spent rounds and 2 rounds that were not removed from that .44 revolver.
Correct.
I'm not going to offer in the actual live rounds, but I want to show you State's Exhibit number 6, the spent rounds, okay?
Okay.
Investigator McChesney, State's Exhibit 6, does this appear to be the 3 spent rounds that would have been removed from the .44 revolver?
Yes, it does.
And they were collected and taken back to the DCI evidence room, the Mason City Police Department evidence room as well?
Yes, it was.
The state would offer into evidence State's Exhibit number 6.
Exhibit 6 is admitted.
Permission to approach again, Your Honor.
You may.
So we talked about the rounds that were removed from the gun. When you searched the defendant's apartment, did you find other items that were related to the in the apartment?
I recovered some bullets in the wall.
And earlier, if I may publish one of the diagrams, Your Honor, or I guess they're not admitted yet, so I'll wait on that. Sorry, Investigator McChesney, can you describe where you saw bullet holes in the apartment?
Correct. There was one through the entry door of the apartment, and there's 2 in the wall just to the right of the door as you're looking from inside the apartment out the door.
So the apartment door to the defendant's apartment, which was what number?
2.
2, there was a bullet hole through that door?
Correct.
Did you follow the bullet hole? Did it go through the entire door?
Yes, it went through the door and then through the outside, the wall behind the door also.
Did you see if anything entered that wall? In other words, you tried to track the bullet that went through the door?
Correct.
How did you do that?
It's kind of like a kit that just, there's a long rod that you put through the hole and it shows the trajectory of the bullet.
Okay. And were you able to, in the hallway, recover any bullet or bullet fragments?
Yes.
How about in the apartment? You said if you're standing in the defendant's apartment door at that doorway, facing the door. Is the handle to your left or right, the doorknob?
The doorknob would be to your left.
And you said there was 2 other holes in the apartment to the left or the right of that door if you're facing it from inside?
If you're facing it from inside, it would have been to the right.
And those 2 holes, what did they go into? What type of material wall are we talking about?
They entered through sheetrock and then hit a brick wall behind that.
And the brick wall behind the sheetrock, was that all still in the defendant's apartment?
Yes.
Did you try to collect any bullets or bullet fragments from that?
Yes, we did.
And how did you go about trying to do that?
We cut out a square around the entry holes where the bullets went through the wall. Then that's when we located the brick wall. So then we cut a hole down at the floor level to try to get the bullets out since they hit the wall and fell down.
Were you able to recover any bullets or bullet fragments?
Yes, we were 2 of them.
And then what did you do with those?
They were collected and put in evidence.
And the stuff that you're collecting at the scene that you're telling the jury about, was there one person who was sort of the person that you were giving the items to?
Yes.
And who was that?
Evidence technician Tammy Orr.
Now you said you cut the sheetrock out as well.
Yes.
Is that fair?
Yes, we did.
May I approach again, Your Honor?
Yes.
Investigator McChesney, I'm not going to remove it yet. Is this what has been marked as State's Exhibit number 8? Prior to coming to court today, have you had a chance to look at this?
The day of, yes.
Okay. And is this the sheetrock that you would have removed from Mr. Whaley's apartment?
Yes, it is.
The state would offer into evidence State's Exhibit number 8.
No objection.
Exhibit 8 is admitted.
Try to be careful with it because I know it can be fragile. I'll hold it up. Investigator McChesney, if you could explain to the jury, if you were looking at this, do we know if it was on the wall, which way is top to bottom, or do you know by just looking at the sheetrock?
I don't by just looking at the sheetrock.
We'd have to look at some photographs.
Yes.
Okay. So after you searched the defendant's apartment, did that include the hallway, the entryway as well?
Yes, it did.
Did you just follow the same type of protocol, taking photographs of items, or someone from law enforcement took photographs?
Yes.
After the search was completed of the entryway, as well as the apartment, was the garage also looked at?
Yes.
And photographs taken of anything that was relevant there?
Correct.
How about the defendant's car? Did you have a search warrant to search that as well?
Yes, I believe we did.
And did you search or have law enforcement officers search his car?
Yes.
Did you take photographs of the car as well?
Yes, photos were taken.
When I say you, I apologize. You or other officers that were in the investigation?
Yes.
May I approach?
You may. The rest of the court may be seated. Thank you. Has the jury reached a verdict?
We have your
Mr. Hochrafer, would you give your verdict to Ms. Myring so that I can review it? On the verdict form, we, the jury, find defendant Larry Donnell Whaley guilty of in the second degree, signed by Todd Hochrafer?
Yes, sir.
Foreperson. Mr. Adams, would you wish to have the jury polled?
Please, Your Honor.
Ms. Myring? And folks, this process is just a way for the court to confirm that each member of the jury agrees with the verdict. Ms. Myra will read your names, and as your name is read, if you would just answer whether you agree or disagree with the verdict that I've read. Ms. Myra?
Madeline Cash. Jennifer Clancy. Todd Holbreaker. Joyce Hull. Jill Lukovich. Jane Miller. Daniel Nauman. Enos Price. Constance Smalley. Timothy Thomas. Cody Eugen. Thomas Waldschmidt.
Members of the jury, with the rendering of your verdict, your work is done. If I could impose on you for just a little bit more, I'd ask that you return to the jury room and wait just a few minutes. There are some things I need to address in a courtroom with the parties, and as soon as that's done, I'd like to come back and visit with you, and if there's questions you have, answer those. But I thank you for your time. Ms. Myers, you'll take the jury back to their room. All rise to the jury, please. Court may be seated. Mr. Whaley, the jury is found guilty of second degree. I want to set a time for sentencing before we finish for today. I will be requiring that a pre-sentence investigation report be prepared prior to sentencing. At this time, I'm looking at either February 5th or February 6th as potential dates for sentencing. The 5th is a Monday, the 6th is Tuesday. Mr. Adams and Ms. Eimerman, does one day work better than the other for you?
January 6th, Your Honor, would be better for us.
February?
I'm sorry, February 6th. Yes.
Okay, all right. And counsels, Mr. Hammerman or Mr. Dylann, any problems with February 6th?
The 6th would work with us as well, Your Honor.
All right. Sentencing will be set for February 6th at 10:30. Mr. Whaley, if you wish to move for a motion for new trial or bring a motion or rest of judgment, these are both motions where you would challenge anything that you feel was not done properly in the course of your trial. Those motions must be filed within 45 days from today's date and no later than 5 days before the sentencing. If you have any questions about either of these motions or the issues that you can raise in these motions, will you make sure that you talk with Mr. Adams and Ms. Eimerman about those issues, those questions? Is that a yes?
Yes.
All right. Mr. Whaley, because second degree is a forcible felony, it's defined as a forcible felony under Iowa law, you are not eligible for bail while you wait sentencing. So at the conclusion of our proceedings today, I'll have the deputies return you to the jail, and you'll be held there until sentencing on February 6th. Anything more for the record?
No, Your Honor.
Mr. Adams?
No, Your Honor.
All right. Counsel, when I see a job done well, I feel it's a good thing to comment on that. I appreciate the professional manner in which this case was tried. To the extent there was any issues, personalities weren't brought into it, and everything was dealt with professionally, and that makes it much easier for the court to conduct a trial, and it makes it easier, I think, for the jury to focus on the issues. And so I want to let you know I appreciate your efforts as advocates. So that will conclude our proceedings today. We'll return for sentencing on February 6th. Thank you.
In June 2013, Falls Lake was filled with peace until Joanna Madonna's actions changed everything. Seeking redemption after her husband's death, Joanna Madonna hoped to clear her name, but facing him in court revealed that no trickery could absolve her guilt. In this lawyer's narration, we will witness the chilling reality of the brutality that death can embody.
Good afternoon. More than 12, 5 the back. One so forcibly inflicted to his jaw that it shattered his dentures. Dumped, his shirt pulled over his head, abandoned on the side of the road. That is the way that the victim in this case, Mr. Jose Perez, was found on the morning of June 16th. Ladies and gentlemen, my name is Lauren Freeman. I am your district attorney, and me, along with Deborah Shandles, an assistant district attorney, will be presenting to you the evidence by which you will find this defendant guilty of first degree. Today, my job is quite simple, as the judge has said, and that is to try and provide an outline, a framework of what the evidence will be. This is unlike many of the cases that we have here in this courtroom. This is not a case about who did it. This is a case about what was in the mind of the defendant at the time that she killed her husband, Mr. Perez. There are a few things as you get ready to listen to the evidence that I want you to know about. First of all, I want you to know about the victim. Mr. Perez, as you've heard during jury selection, was a Vietnam veteran. He was a father, a grandfather, and a friend. He was like many people who've moved to our community in the last few years. He'd come here to spend more time with his grandchildren, the children of Vanessa, who is here in the audience today. Having served in Vietnam, he was disabled, and you're going to hear a lot of testimony throughout this case about some of the physical limitations that Mr. Perez had, including the fact that he had neuropathy, diabetes. He had had a liver transplant. At one point, he had suffered from cancer. His doctor had even prescribed for him special tools to allow him to eat because he had limitations with the way he could use his hands and with his ability to balance. And so they were in the process of trying to install a ramp to get in and out of his house. Mr. Perez was also, as you've heard us discuss, a recovering alcoholic. He had been sober for 40 years. He took his recovery very seriously. He went to meetings repeatedly every week. He also helped others break the power of addiction over their lives. It was at one of those meetings for recovery that he met the defendant, Miss Madonna, in 2009, and they shortly married thereafter. As we've talked about, the purpose of this case is to try and determine what happened on the night of June 15th. We will have the responsibility of proving to you beyond a reasonable doubt what the intent of the defendant was at the time of the death of Mr. Perez. As you think about how we prove somebody's intent or what's in somebody's mind, I would ask you to pay attention to certain particular things. Those things include what exactly the defendant did leading up to the incident in question, what happened immediately thereafter. You're going to hear testimony that on the day of the murder, Miss Madonna went to South Carolina to visit a family member who was dying of cancer. It was from that family member that she obtained the knife and a gun. The knife that you will hear was found at the crime scene.
And like when you said you came home, you said Jose was in the garage already. So
yeah, Jose was in the garage.
And from the sheets, had you guys started talking about, had you told Jose that you were going to be separating with him at that point or not?
I hadn't told him. I suspected that he might know, though, because I had told my father that I was asking him, and he had been home all day with my dad, so I had suspected maybe my father had said something. I had mentioned something about old timers drinking on my Facebook, so I thought maybe he had gotten wind of it.
And when you say dollar store, do you perhaps mean a Family Dollar or?
Yeah, to me, any dollar store is the dollar store. Like, I just kind of lump them all together, the dollar store. So the one that we went to was north of that Sheetz. So I believe that is a Family Dollar.
And what did you get from the Family Dollar?
I got nail polish because I was making some jewelry, and I got a candle lighter, like one of those long lighters for the candles.
And you said you got a soda from Sheetz. What kind of soda did you get?
I got a big thing of Mountain Dew.
And does Jose go inside the store?
He came into the dollar store for a couple minutes, but since he didn't have his wallet, he didn't feel like looking around, so he went back out.
And how long were you in the Family Dollar?
Just about maybe 5 minutes. I don't know. I was looking around and just went and checked out, so.
And so you and Jose get back in the car, and who is driving?
I'm driving at this point.
And where are you going from there?
So we're just going to start driving. My plan is we're just going to drive around that area because he lived in Youngsville and that, before we got together. So it's sunny out and we start having the conversation, and I start going into this rehearsed speech that I have about why I want a divorce.
And what did you tell him?
I told him that I knew he was drinking, I knew he was cheating, I was done with the lying, and this time I'm not backing down this time. I need to take you to Fred's and you need to go to rehab.
And what did he say to that?
He had started initially the way he usually reacts. Joe, I can't live without you. Joe, I love you. You're my whole world. I'll kill myself if you're not here. And I said, this is different. I need you to tell me where Fred lives. I'm taking you to Fred's.
Did you know where Fred lived at that point?
I knew Fred lived near us. I knew he lived near the intersection of 98, but I wasn't sure specifically where he lived.
And so guys are just driving in the country at this point, and you're talking to him about it?
Yeah, we're driving. We're heading towards, through Youngsville towards Rollsville, which I believe is 98, which is the main way that you get there. And we're talking, and he's getting more and more upset. He's getting more agitated.
And what does he say to you?
He started getting loud, and he starts looking like he's panicking, and he starts clutching his chest, saying, I'm going to have a heart attack. I'm going to have a heart attack. You need to pull over.
And what do you do when he says he's going to have a heart attack?
I pulled over into a parking lot on the right-hand side. There was like a church there on the right, and I pulled into the parking lot.
And what happened then?
I got out of the car on my side, and he got out of the car on his side, and I came around the back of the car to go over and help him with whatever he said he was going to throw up. And by the time I was coming around the back of the car, I heard and I looked up, and he was pointing the gun at me. What did you do when you saw him pointing the gun at you? I was in shock. I just stood there for a second, and then he turned the gun on himself, and he had it pointed at his, I'm not sure if he had it pointed under here or where he was pointing it, but he had it pointed at himself. And at that point, I believe he's going to kill himself.
And you said he had at you before then?
He shot at me, yep.
And what did you do then when you saw him pointing the gun at himself?
I lunged forward to grab his hand and to pull his hand away from his face. And the gun went off at that point and shot him in the face. And I grabbed,
What happened then after you think he...
And I grabbed the gun, and the gun went off again. I don't know if that hit him or it didn't hit him. I don't know what happened. But that one shot had, he was bleeding. He was bleeding from that to his face.
What were you thinking at that point?
I was thinking he was trying to kill himself, and I'm in shock because and he's not even really, he's just yelling now, and he's mad, and he said he's going to walk to the hospital.
You had a meeting, so did you have an AA meeting that day?
Yeah, went to the AA meeting in the morning.
And then you met with Chad?
I met with Chad later on, yep, about 7:30, 7 o'clock, 7:30.
Why did you meet with Chad that day?
Well, I mean, I'd like to say Chad was the one person that knew everything about what had been going on with me and Jose. But I went over to Chad's.
Do you understand how that looks at this
Absolutely.
point? How does it look?
It looks like I was cheating on Jose.
And you were cheating on Jose, correct?
Yes.
Did you Jose Perez the day before so you could start a relationship with Chad?
No.
And since that day when Jose, have you started a relationship with Chad?
No.
When you were at Chad's house, did you tell him what had happened that night?
I didn't tell him. I mean, I told him the whole thing about Florida. I told him the same thing that I've been telling myself and telling everybody else. So I didn't tell him. I couldn't tell anybody.
And when you knew the police were at the house, did you come home immediately?
I did. I left immediately.
And when you knew the police were at the house, did you know what they were there for?
I had started to suspect at that point that he hadn't gone to Fred's.
And you're saying that you don't remember how many times you saw him or where you saw him?
Nope.
When you had to see your husband, did it feel like a blackout?
Yeah, I was completely just in like a frenzy adrenaline thing.
And was that brought about by you thinking you were going to do it yourself?
Yep.
When the police were there, and the police were finally there, you didn't tell them what happened, and then Jose had tried to shoot you, and then Jose had tried to strangle you and tell them that you had to defend yourself?
Nope.
Why not?
I was still going with Florida until I heard otherwise. That's what I was going to go with.
Donna, after all this, have you gained anything whatsoever from the death of Jose Perez, your husband?
Nothing.
Has any member of your family ever gained anything whatsoever from the death of your husband, Jose Perez?
Nothing.
And have y'all received any kind of benefits from the death of your husband?
No, we haven't.
Did you think that you would?
No.
Do you know about anything that Jose owns in an estate that would come to you?
No, he didn't own anything.
Were you ever able to confirm that Jose was ever an assistant district attorney?
No. I found out about October, about 4 months after this happened, that there was no record of him ever having had that profession.
And through all this, has the death of Jose Perez made your life any better?
No.
What have you lost because of this?
Just being separated from my kids has been, I mean, there's no way of describing how that has shattered everybody's lives. The girls haven't been able to have any stability since this happened, and y'all know that my father was moved out to Vegas, and then he died after that. So my family's life has been completely shattered.
If Jose had just left and went to Florida or just went somewhere else on his own accord, would you be able to keep the lifestyle that you had?
Oh yeah.
And how would you do that?
I mean, I was I knew we had to downsize a little bit, and I was looking for a 3-bedroom house for me and Papa and Isabel. I mean, I was ready to do that. I was looking forward to my little full-time job that I was getting with, the lady that I had been working with for a little while. So, I mean, it was going to be a struggle, but like I had said, I'd rather be alone and be a functional mom than to be in a marriage where I couldn't trust my spouse.
I don't need to be hurt anybody.
Your Honor, Ms. Gant, the victim's daughter, would like to make a brief statement to the court, if she could. Vanessa.
Do you object to me viewing her in her stand? Yeah, I don't have an objection to that. Yes, ma'am.
Nothing will bring my dad back. The time taken away from me, from my children. May God have mercy on you. This suffering. I just ask you to take into consideration.
Mr. Rhodes, I'm going to ask you some questions. The appropriate response to each question would be either a yes or a no. Has the jury reached a unanimous verdict?
Yes.
Have you recorded that unanimous verdict by placing a check or an X mark that stays next to the appropriate verdict on the verdict sheet?
Yes.
Have you dated the verdict sheet?
Yes.
Did you sign it?
Yes.
Is it in the vanilla envelope you hold in your hand?
Yes.
You give that to the sheriff, you may be seated. Madam Clerk, take the verdict, please.
Ladies and gentlemen of the jury, your foreperson has returned a verdict in file number 13-CRS 214536, the state of North Carolina versus Joanna Roberta Madonna. We, the jury, unanimously find the defendant, Joanna Roberta Madonna, to be guilty of first-degree murder. This, the 28th day of September, 2015. Is this your verdict? So say you all.
Yes.
Thank you.
Ladies and gentlemen, if you all agree that that was your verdict, if you'll raise your hand. Vote you reflect that all 12 jurors raised their hands. Anything further with this jury for the state of North Carolina?
No, Your Honor.
Anything further with this jury for the...
No, I don't ask the jury ultimate shot.
Ladies and gentlemen of the jury, you're going to be asked individually about the verdict that your foreperson has returned. I'll start with the foreperson first, but you'll essentially be asked the following questions. Your foreperson has returned a verdict of guilty of first degree. Then I will ask you, was this your verdict? And you will answer that question either yes or no. You'll then be asked the question, is this still your verdict? And you will answer that question either yes or no. If you do not understand the question I asked of you, let me know, and I'll be glad to repeat it. And again, any question I ask of you will be and can be answered either yes or no. Madam Clerk, call the roll of the jury, but call the name of the foreperson, Mr. Rhodes, first.
Mr. Rhodes, if you would, please stand.
Mr. Rhodes, as foreperson of the jury, you have returned a verdict of guilty of first degree. Was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, sir. You may be seated. Your foreperson returned a verdict of guilty of first degree murder. Was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, ma'am. You may be seated.
Ms. Anderson, if you would, please stand.
Your foreperson returned as a verdict of the jury, a verdict of guilty of first degree murder. Was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, ma'am. You may be seated.
Mr. Greenspan, if you would, please stand.
Mr. Greenspan, your foreperson returned as a verdict of the jury, a verdict of guilty of first degree murder. Was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, sir. You may be seated.
Ms. Brown, if you would, please stand.
Ms. Brown, your foreperson returned a verdict of guilty of first degree murder. In this case, was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you. You may be seated.
Ms. Robinson, if you would, please stand.
Ms. Robinson, your foreperson returned as a verdict of the jury, a verdict of guilty of first degree murder. Was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you. You may be seated.
Mr. Abney, if you would please stand.
Mr. Abney, your foreperson term is a verdict of the jury, a verdict of guilty of first-degree murder. Was this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, sir. You may be seated.
Mr. Byers, if you would please stand.
Mr. Byers, your foreperson term is a verdict of the jury, a verdict of guilty of first-degree murder. Was this your verdict?
Yes, sir.
Is this still your verdict?
Yes, sir.
Thank you, sir. You may be seated.
Mr. Gray, if you would please stand.
Mr. Gray, your foreperson term is a verdict of the jury, a verdict of guilty of first-degree murder. Is this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, sir. You may be seated.
Ms. Lewis Jenkins.
Ms. Lewis Jenkins, your foreperson term is a verdict of the jury, a verdict of guilty of first-degree murder. Is this your verdict?
Yes.
Is this still your verdict? Thank you, ma'am. You may be seated.
Mr. Jefferson, if you would please stand.
Mr. Jefferson, your foreperson term is a verdict of the jury, a verdict of guilty of first-degree murder. Is this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, sir. You may be seated.
Mr. Villar, if you would please stand.
Mr. Filler, your foreperson returned a verdict to the jury, a verdict of guilty of first-degree murder. Is this your verdict?
Yes.
Is this still your verdict?
Yes.
Thank you, sir. You may be seated. Anything further on behalf of the defendant?
Nothing at this point in time, Your Honor.
I have nothing to say other than to thank the jury and thank Your Honor for taking so much time to consider my case.
The verdict of the jury is hereby accepted by this court in order recorded. Madam Clerk, the matter of Southern North Carolina versus Gianna Roberta Madonna. Senator Peter at Oakland Court was found guilty by a jury in 13 CRS 214536 of the offense of first-degree murder in violation of General Statute 14-17, which is a felony class A. For the judge decreed the defendant be in prison for a term of her natural life without parole. She gives notice of appeals in North Carolina Court of Appeals, and I will appoint the appellate defender on her case. So you question for sure. Ladies and gentlemen, this would conclude your jury services for this session of Superior Court here in Wake County and for the next 2 years. For your services, let me tell you first my feelings about our criminal justice system, or jury system, are best summed up in a statement by T.K. Chesterton. He said that our civilization is decided, and very justly decided, that determining the guilt or innocence of men is a thing too important to be entrusted to trained men. But he wishes for light upon that awful matter to ask men who know no more law than I know, but who can feel the things that I felt in the jury box. Nor wants a library catalog or the solar system discovery any trifle of that kind. It uses up its specialists. But when it wishes anything done which is really serious, it collects 12 of the ordinary men standing around. The same thing was done, if I remember right, by the founder of Christianity. When we open court in this courtroom, we stand, and when we close court, we stand. You haven't been here, been in the room. But we stand in reverence and respect for justice as it's administered in the state of North Carolina. And that has been represented these past 2 weeks by your presence and your participation here in this courtroom. And for your presence and participation, I thank you. For your services, you're going to be paid the grand sum of $12 for the first day you were here. The next 4 days, you got $20. And then for the next 5 days, you got a raise to $40 a day. And I recognize that for most of you, that represents a financial sacrifice. But it's a small sacrifice for you to pay, for you to have the privilege of participating in our constitutional form of government and being a constitutional life. Not only for Ms. Madonna, but for all of us here in North Carolina. For your services, I thank you. Because of your service here this week, you may not serve on another trial jury or grand jury of this state for the next 2 years. If your son is there, let that clerk know of your service here. You should not have to serve in a state court. If you need an excuse to your place of employment, they can provide that for you in the jury lounge downstairs. Any of you have any questions about our criminal civil justice system apart from the case that was just tried? If you have any comments about your jury service, and I won't mean how you were treated, whether we did some things right or we did some things wrong, you're the way we know what we're doing. And I assure you that whatever you say will not make you angry. No one has any comments you want to make at all? Now, ladies and gentlemen, I told you repeatedly during this trial that you could not talk about this case with anyone else. You're now released from that. You may talk about this case with anyone in the whole wide world you want to. That would include the lawyers who are involved in this particular case. We practice law. We don't ever perfect it. You are the expert on being a juror. And so it may be instructive to them if you tell them what they did right or wrong in this case as they practice their profession in the future. If somebody approaches you, one of the lawyers, and you don't want to talk to them, say, thank you so much, I don't want to talk to you. But however this case came out, they will respect you and what your position is. Any other questions or comments you have?
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.